Good afternoon, good morning to wherever you are. My name is Marcy Koski. I'm a partner and the leader of the firm's National Consumer Financial Services practice, which includes both a strong regulatory practice and a litigation practice. We advise and represent all kinds of companies and lenders in the consumer finance ecosystem and advise on all kinds of issues, big and small, dealing with issues relating to state laws and state regulators to federal laws in the CFPB. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all the questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That's all for the housekeeping items. Let's get started with our program. Joining me today are my excellent Wisconsin consumer credit colleagues, Kat Albrecht-Weezy, Becky Babelsick, Natalia Cruz, and Lisa Lawless. Starting with Kat, Kat is one of our consumer finance regulatory attorneys based in the Madison, Wisconsin office of our firm. Kat works with our financial institution and consumer lending clients, helping them, for example, establish policies, procedures, prepare agreements and disclosures, and produce advertising in line with state and federal regulations. She advises on the alphabet soup and also has a specialty in Wisconsin consumer finance law, including the Wisconsin Consumer Act, Wisconsin First Lien Law, and Wisconsin Marital Property Act. Becky is one of our consumer finance litigation attorneys based in Milwaukee, Wisconsin. She represents our clients in a variety of litigation, including cases involving the Wisconsin Consumer Act, FCRA, and the Fair Debt Collections Practices Act. Becky also has experience with appellate work and class action defense. Natalia Cruz is another of our consumer finance litigation attorneys, and similar to Becky, her practice consists of primarily assisting installment lenders, financial institutions, and other companies defending their interests in alleged violations of state and federal consumer credit protection laws, including the Wisconsin Consumer Act, the FDCPA, TILA, and the Fair Credit Reporting Act. Lisa Lawless, who I've practiced with my entire career, is another consumer finance litigator with a special expertise in appellate practice. Lisa's practice focuses on defending consumer finance related claims in both federal and state courts and arbitration, both individual consumer claims and putative class claims. Lisa has handled cases from beginning to end, including all the way up to the Supreme Court when necessary. With that, I will hand that over to our first speaker, Becky.
Hey, everybody. Good afternoon. Good morning. We're going to kick things off with the Credit Box versus Weathers decision. This is a recent Court of Appeals case, Wisconsin Court of Appeals case. The case started off as a small claims debt collection case on a defaulted loan. Mr. Antoine Weathers had took out a loan from Credit Box for about $500 with just under about 400% interest. He then shortly thereafter defaulted, so Credit Box filed a small claims collection action against him, seeking to collect about $2,200. I mentioned the loan terms in part because this interest rate may have had an unwritten effect on how the court ruled here. I also want to mention that this is happening in Dane County, which is a historically very consumer-friendly venue. So going back to the loan, Credit Box files the small claims action. Mr. Weathers doesn't contest. Credit Box gets a default judgment. Then, of course, Mr. Weathers goes and hires an attorney. His attorney moves to reopen the case. and that the court grants the reopening. So as soon as the case is reopened, credit box, not wanting to deal with this case, not wanting to deal with the potential counterclaims, moves to dismiss voluntarily. There's two different Wisconsin procedural statutes they're looking at here. One allows them to dismiss as a matter of right, and the other allows them to dismiss if the terms are so just that it would be just under the circumstances. Mr. Weathers opposes this attempted dismissal and files an amended answer with two WCA counterclaims. One is for a violation of the duty of good faith, and the other alleges unconscionability. So credit box, again, tries to dismiss these counterclaims for failure to state a claim. And it's really important to note that this is a motion to dismiss. So all that the Court of Appeals is going to be considering here is whether they stated a plausible claim, not whether Mr. Weathers is actually going to be able to prove this claim. So the Circuit Court grants credit box's motions, dismisses case in chief, dismisses counterclaims, case over, until, of course, Mr. Weathers appeals to the Court of Appeals. The Court of Appeals has two questions focused on these two counterclaims. The first is, did Mr. Weathers state a good faith counterclaim under the WCA's counterclaims good faith statute? Spoiler alert, yes, he did. And then the second question was whether Mr. Weathers could bring an unconscionability counterclaim against Credit Box, even though Credit Box had voluntarily dismissed before he filed the counterclaim. And again, the Court of Appeals agreed with the consumer and found that, yes, this claim could survive dismissal of the case in chief. So turning to the obligation of good faith under the WCA. The WCA includes this statutory language that you can see regarding the obligation of good faith. But there's never been any real litigation or precedent regarding the scope of this statute. In fact, it seems like some folks, like perhaps Credit Box in this case, just assumed that it was the same as the general common law duty of good faith that is implied in every contract. The Court of Appeals said, no, that's not the case. It has this question of first impression, how is it going to construe the scope of this statute? Court starts off by noting, as courts often do, that the WCA is intended to be a consumer-friendly statute. And then looking at this duty of good faith, the court concludes that this section, 421.108, imposes an obligation of good faith on the parties for both the performance or enforcement of both agreements that are subject to the Act, as well as duties that are defined under the Act. And then turning to the second sentence, the court finds that the WCA duty of good faith is not equivalent to the common law duty of good faith. Under the WCA, the good faith obligation has two parts. The first is honesty in fact, and the second is the observance of reasonable commercial standards of fair dealing. So honesty in fact is similar to the common law obligation. It's an, quote, an honest intention to abstain from taking unfair advantage of another through technicalities of law, failure to provide information or give notice, or other activities which would render the transaction unfair. On the other hand, the second part, the reasonable commercial standards of fair dealing, that's narrower than the common law obligation, the Court of Appeals says. This language requires an objective set of standards as opposed to common law statutes. The common law standards generally broad construction of just it's good faith is the opposite of bad faith. So the court concludes that to state a claim for a violation of the duty of good faith, the plaintiff is going to have to point to some sort of relevant commercial reasonable standard of fair dealing that could have been violated. In other words, there needs to be some objective standard to point to. So in this case, Mr. Weathers had put forward three different potential theories for a good faith violation. First, the first potential basis that he offered was these EFT withdrawal allegations. He had alleged that Credit Box had attempted an unscheduled electronic funds transfer withdrawal from Mr. Weathers' bank account. And this was after a prior withdrawal attempt had been unsuccessful. Even though this is a motion to dismiss, Credit Box was able to introduce Mr. Weathers' EFT authorization form under the incorporation by reference doctrine. So they get this EFT authorization form before the court. The court looks at the form and says, this EFT authorization authorized this exact withdrawal you're taking issue with. So there's no violation of good faith here. That those allegations fail to state a claim. The court next looks to the allegations about Credit Box's decision to charge off the debt. Credit Box charged the debt off after about 60 days after default. Weathers points to this federal guidance put out by the Office of the Comptroller of the Currency and says that charge-offs should not happen until about 120 days after a missed payment. And then he also sort of generally argued that just Credit Box should have been communicating with him more. The court, again, looks at the EFT authorization form, looks at the loan agreement, and says neither of these documents require that Credit Box communicate with you more. They don't require that you wait 120 days. 60 days is fine to charge off. So again, there is no objective reasonable standard, and the good faith counterclaim is dismissed. Now, this third set of allegations, this is about the notice of right to cure. For context, this is one of the most heavily litigated areas of the WBA. We see claims all the time about failure to provide a notice of right to cure before bringing suit. So Mr. Weathers here, he alleges that Credit Box had unlawfully accelerated the debt and filed its action before it provided him with this 15-day notice of default and an opportunity to cure, as required by the WCA. And here the court said that the WCA statutes, they require this notice. This is going to be a plausible, reasonable commercial standard to give rise to a good faith violation. So it's by pointing to a statutory violation, Mr. Weathers was able to create or allege a good faith claim. And then the court was also, I want to emphasize again, this is on a motion to dismiss. As far as the first two theories were concerned, the court wasn't saying that these could never be good faith claims. The court was saying that they had not been alleged. So maybe Mr. Weathers could go back, rework it into a plausible claim by pointing to some objective, reasonable standard. Now, if the notice of right to cure stuff sounds familiar, you might be thinking about a case from a couple years ago, Security Finance versus Husch, argued by our own Lisa Lawless. In that case, the Wisconsin Supreme Court had to answer whether the failure to provide a notice of right to cure could be a violation of a different WCA statute, section 427.104, which has to do with actions prohibited by debt collectors. In the Husch case, the Supreme Court held that the remedy for bringing suit before giving a notice of right to cure was just you dismiss without prejudice. So then the creditor goes and gives the notice and can bring the suit again. Credit Box is now sort of a little bit of a workaround to the Supreme Court's holding. Obviously, it's a Court of Appeals case. It can't abrogate the Supreme Court. But the Court of Appeals says, well, this is a different statute. We're looking at the good faith statute here. We're not looking at the Supreme Court statute, at the same statute the Supreme Court was looking at. So we can find that you're able to state a claim for good faith under this good faith statute. And then, so sort of turning to the second part of the Mr. Weathers claims, he also was concerned about, he was trying to bring an unconscionability counterclaim. Different Supreme Court case from, again, a couple years ago, the Wisconsin Supreme Court said you can only bring an unconscionability counterclaim in response to an action by the creditor. In Duncan, the consumer had sued the creditor and repo company for unconscionability. The unconscionable conduct had stemmed from alleged allegations regarding the repossession. And that Duncan court had said, no, you can't bring this separate claim. You can only bring an unconscionability claim in response to actions or other proceedings by the creditor to enforce its rights. And this sort of tracks with the common law understanding of unconscionability. It's normally just a defense to a breach of contract claim. It's not a separate claim you bring affirmatively instead. So the Credit Box court was concerned that creditors would just do sort of what Credit Box had done here and try to dismiss their case as soon as the consumer lawyered up. So the court said, no, even though Credit Box sought to dismiss its case in chief, the case was still there. So the counterclaim could go forward because it was in response to the original case, even though it had been dismissed. So what are the takeaways from this case. So one of the biggest thing here that the court did was it looked at what good faith is and how you're going to state a good faith claim. On the one hand, there seems to be a little bit of a workaround to the Supreme Court's decision in Husch. A consumer can now bring a cause of action, albeit not the 427.104 cause of action, for if a creditor fails to give a notice of right to cure before suing. The statutes have slightly different penalties. So the statute that Husch said you could not bring a claim in response to, that allows for a maximum penalty of $1,000 or actual damages, whereas the statutory penalty for a good faith claim is $25 or actual damages. There could be actual damages in this kind of case, though. And what's sort of really driving the case for both claims is attorney's fees, which are available for both claims. On the other hand, Credit Box did make clear that a plaintiff is going to have to point to some sort of objective standard to state a claim. Any sort of procedural violation might be enough based off of the court's conclusion in Credit Box. But at least the consumer is not going to just be able to say, this felt unfair, I don't like this, and they need to have some sort of standard to get to the good faith claim. It's also worth remembering this case was a motion to dismiss. The court found that a claim was plausibly stated. Weathers still might not be able to prove that Credit Box's noncompliance was actually bad faith. His own lawyer conceded that he would likely need expert testimony. And, if the notice is just not compliant, creditors might still be able to argue that there was no violation of the duty of good faith. The notice was sent, you're looking at the substance at summary judgment. And lastly, Credit Box also sort of broadens the availability of unconscionability claims. Previously, there was an opportunity creditors might have been able to just dismiss voluntarily anytime a defense or counterclaim comes in. But Credit Box clarified that strategy probably won't be enough to dodge unconscionability counterclaims. The claim is still going to be in response to the original action, even if the case in chief has been dismissed.
To chime in, and then we'll shift to another topic. On unconscionability, the Credit Box case is interesting because it says it may be available to be brought as a counterclaim. However, in Credit Box, as I recall, the main focus by Credit Box was that under the Duncan case, you can't raise unconscionability as an affirmative claim if the action is voluntarily dismissed. And so in Credit Box, I don't think the issue of is not providing a notice of right to cure unconscionable conduct. The court didn't decide that. It's not addressed in the Court of Appeals decision. And in a lot of cases, I've seen consumer lawyers bring unconscionability as kind of a defense/counterclaim that's kind of like the tail wagging the dog, because the things that they're complaining about, maybe your notice is a little defective, maybe it doesn't have everything it needs in it, but does that really equate to unconscionability under the law? We would argue no, and that's an issue for the judge to decide. But that is an open question for courts to decide.
And then I just want to, if you don't mind, Lisa, just chime in on a few points. Credit Box is an interesting case because there are no other decisions that interpret this good faith statute. So this was an issue of first impression. Additionally, it is a follow-on to what was a good section of the decision in Duncan, which was not all great, but Duncan is great for the proposition that unconscionability can only be brought as a counterclaim, whereas before we had plaintiff's counsel regularly bringing it as an affirmative claim. So Credit Box certainly chips away at that, but it still is Duncan is a Wisconsin Supreme Court issued decision. So it is still obviously is more persuasive, precedential compared to Credit Box. And then the third thing is most of our Wisconsin Consumer Act litigation is based on right to cure. So this does give consumers or plaintiffs' attorneys another avenue to attack right to cure compliance.
Yeah, absolutely. Thank you so much, Marcy and Lisa. And with that, I just want to pass it off to Lisa.
Thanks, Becky. to speak on counterclaims or class action counterclaims in consumer actions. Sometimes you'll see a creditor suing a borrower on a debt that's defaulted, seeking to recover under the debt. A lot of times these matters are quite small, can be in small claims court. Other times they're in large claims court. And where a consumer lawyer surfaces to represent the consumer, so in some situations we've seen the consumer lawyers bring a counterclaim class action, meaning alleging that there's some aspect of the creditor's behavior, maybe notices, maybe disclosures that are consistent across customers, and allegedly some aspect of their conduct doesn't comply with the WCA, and so they bring a counterclaim class action. Recently, in the last year, we've had a case in Brown County Circuit Court, which is where Green Bay is, where it was just a simple collection action on a student loan debt. The borrower has a consumer lawyer representing him, and he filed an answer and amended counterclaims that attempted to bring a class action, alleging that certain aspects of the lender's conduct and disclosures violate the Consumer Act. We, in reading, we have the 426.110, the Wisconsin statute under the Consumer Act relating to class actions. And if you look at the language of that statute, it appears to say that class actions under the WCA are brought by the borrower as the plaintiff commencing a class action. And so we move to dismiss the class action counterclaims under the Consumer Act, arguing that you can't bring Consumer Act class action claims from the counterclaim context. That issue had not been considered in any published decision or any decision that can be cited as authority. You do see situations where it wasn't argued, and so a counterclaim class action proceeds. The issue wasn't raised. There's aspects of the statute that, to me, we argue make clear that it has to be a plaintiff bringing a class action counterclaim. Class action counterclaim. In the decision we got from the Brown County Circuit Court, the judge agreed with us that under the terms of the Consumer Act, that class actions can be brought by the consumer as a plaintiff and not the consumer as a defendant from the counterclaim posture. The court looked at a case that the other side cited. One of these cases, the Seldal case from 2023, an unpublished but authored decision from the Court of Appeals. In that case, it was an action on a student loan debt with counterclaims and an alleged class action. That moved forward, however, it wasn't argued whether the class action can proceed from the counterclaim context, so that issue just wasn't brought before the court. In the Seldal case, there is a nice ruling by the Court of Appeals holding that the trial level court certified a class of borrowers, but determined that the lower court didn't properly consider all the class action factors, reversed it and sent it back. So to that extent, it's a nice decision as well. The circuit court judge, in looking at the argument, can you bring a class action from the counterclaim context, the judge agreed that you need to look at the language in the 426.110, which has words like commenced, which has words like plaintiff, and those words have particular meanings under the civil procedure statutes. To commence an action means filing a summons and complaint and serving it. A defendant is a defendant who has been sued. A plaintiff is the person who files the initial action in court. So in looking at the 426.110, the court agreed that because it's worded that a consumer may bring a civil action on behalf of himself or herself, and then it has other sections that provide requirements of notice in a demand to cure 30 days before commencement of a class action, commencement meaning filing an action. There's another section that relates to an action for injunctive relief may be commenced on a class action basis without demanding relief. and also includes the language commencement of an action. The other aspect of the class action statute that we pointed to say that Consumer Act class actions can only proceed with the customer as a plaintiff and not as a counterclaim is that subsection 15 of the statute says a plaintiff who prevails shall be awarded a reasonable attorney's fee. So we argued that if it was intended to allow class actions either from the affirmative plaintiff position or from the counterclaim position as a defendant, it wouldn't be limited to allowing attorney's fees for plaintiffs. The court agreed with us, also found other reasons to agree with us, looking to the removal statutes of the United States Code as an example. And the court agreed that under the words of the Consumer Act 426-110, borrowers cannot bring a class action from the counterclaim context. And so it just shows that that just because there's no case law doesn't mean you should not make the argument. Or put another way, look at the statute. If it's worded a particular way, words have meaning. And this judge in Brown County, as Judge Hammer, applied the words as written, which we always like in our practice. The other aspect of this is it's just a trial court decision. It's not binding. Another circuit court could go another way, and there's no court of appeals decisions on this issue. But it's a positive result. It just shows you should make arguments that maybe no one's made before, and start with the language of the statute. So with getting the counterclaims dismissed on the class action basis was a really nice result.
And I just want to chime in and say, when Lisa and Becky were preparing this argument, we recognized it was a creative new argument that hadn't been considered. And it took plaintiffs' counsel by surprise too. And then my second point is, this is such a positive decision, recognizing it's non-binding. It's a positive decision though, because if you get a counterclaim in state court, you can't, a putative class action counterclaim, you cannot remove it under CAFA. So you're stuck in state court, and often companies and lenders would rather be in federal court when defending against a class action. So this would hopefully be adopted by more courts than just Judge Hammer in Brown County, and that would of course help to reduce risk of filing collection actions, for example, in state court.
Thanks, Marcy. The next speaker is Natalia Cruz to speak on the UCC and the WCA. Oops. Oh, I'm sorry. Did I undo your next? Okay, there you go.
There we go. Thanks, Lisa. Yeah, so we're going to stick on the topic of class actions for a bit, but this time a little less positive of an update for creditors, at least as of now, but there's hope as there isn't a decision yet on this issue in Wisconsin. But there has been a recent trend of class action litigation in Wisconsin related to UCC post-repossession notices. And these claims have just arisen in Wisconsin in the last year and a half or so. But since then, they've been coming in hot for sure. So we wanted to make sure all of you are aware of these claims, as you may want to consider potential ways to mitigate the risk of facing one of these claims, especially since they've been asserted most often as a class action. So what we're seeing in Wisconsin are claims that creditors post repossession notices are insufficient if they do not refer to or calculate the deficiency as the fair market value of the collateral. And these cases or the claims might sound familiar even if you're not aware that they have come up in Wisconsin, because they are very similar to those made in other states, including a First Circuit case from about 5 years ago. And that was the Williams case in Massachusetts, which involved claims very similar to what we're seeing in Wisconsin, but instead they are based on the Massachusetts Motor Vehicle Retail Installment Act, which, as we'll talk about, like the Wisconsin Consumer Act, calculates the deficiency using the fair market value. There in Williams, the First Circuit had certified a bunch of questions to the Massachusetts Supreme Court, including the primary question, which was whether a notice of plan to sell property, so post-repossession notice, is sufficient under the UCC, where that notice does not describe the deficiency as the difference between the balance and the fair market value of the collateral. And the Massachusetts Supreme Court concluded that no, the notices that do not calculate the deficiency based on the fair market value are insufficient. So with that background, and just to back up a little bit, when we're talking about deficiency, we mean the balance after the repossession and the sale of the collateral. And under the Wisconsin UCC, the deficiency is calculated by deducting the proceeds of the sale from the unpaid balance of the contract. And we'll get into a little bit more detail about the UCC, and I'll say this a lot, there's no mention of the vehicle's fair market value in the UCC. So specifically in the UCC, there are two provisions that have been, and there have been multiple provisions, but two really that are at issue in these cases in Wisconsin, and they are 409, 614, and 616. And 614 addresses the requirements for the notice of sale or the notification of disposition. And that statute requires a number of pieces of information about the transaction. And one of those is a description of any liability for a deficiency. There's not a particular phrasing that's required for this notice, but the statute does provide a safe harbor for the notice of sale. And that describes the deficiency liability as, again, the difference between the balance and the proceeds of the sale. And then 409-616 includes the requirements for the post-sale notice, so the explanation of calculation of surplus or deficiency. And it goes into how that's calculated or how it's described to the consumer after the collateral is sold. Like the pre-sale notice, the explanation of calculation of surplus or deficiency also makes no mention of fair market value. Instead, the calculation of the deficiency turns on the sale price of the collateral. So you may be wondering, how could anyone possibly claim that the deficiency must be calculated using the fair market value when the statutory requirements for these notices require the sales proceeds to be used? I think that's a very fair question. But what we're seeing in Wisconsin is that the Plaintiffs' Counsel have been basing their argument on a Wisconsin Consumer Act provision, and that is included on the slide here. It's 425-210, that states if a creditor is entitled to a deficiency judgment pursuant to 425-209, the creditor shall be entitled to recover from the customer the deficiency, if any, remaining after deducting the fair market value of the collateral from the unpaid balance. And Plaintiffs' Counsel have been referring to this statute as the anti-deficiency statute. They have been arguing that this anti-deficiency statute, in their words, supersedes the UCC provisions, meaning that even though the UCC says these notices need to refer to the sales proceeds when referring to or calculating the deficiency, this 425-210 supersedes that, meaning that the fair market value instead must be referenced and used in the notices. And this is it's a new argument, one we haven't seen until recently, even though this statute has been on the books for over 50 years, 50. So the claims that we've been seeing in Wisconsin have been a little bit mixed. Most of them have been UCC claims, interestingly enough. They have asserted that it really, when you say it out loud, it doesn't make sense, but they've been asserting that if these notices do not refer to the fair market value, that that is in turn a violation of the UCC. We have seen some cases where they claim violations of the Wisconsin Consumer Act instead, but regardless, both of the statutes provide pretty harsh remedies in Wisconsin. although the damages under the UCC are harsher than the damages that we've seen for the WCA claims that they've been asserting. So that's probably why they're more often asserting the UCC violations. Under the UCC, the customer could recover actual damages plus an amount not less than the credit service charge or finance charge, plus 10% of the principal amount of the obligation, or the time price differential plus 10% of the cash price. So on the other hand, the WCA statute that they've been asserting claims under, and it's the debt collection statute that I think Becky mentioned earlier, is actual damages, which could include emotional distress, which it seems unlikely that there would be any for a technical violation of a notice requirement, but they're available. And then statutory damages between $100 and $1,000, and attorney's fees again. We feel like there are some good arguments for dismissal of these types of claims, but so far there have been, of what we're aware of, there have been 2 Wisconsin courts that have addressed motions to dismiss these claims, and they both denied the motions to dismiss, just concluding that the plaintiffs had stated enough to have a plausible claim. There are a few other dispositive motions that are pending and should be ruled on in the next few months. One was recently granted, but the court has not issued the order yet, so that's something that we expect to come out soon. That case does involve a loan and not a credit sales contract, so it seems possible that that was the basis for summary judgment, because the statute at issue under the Wisconsin Consumer Act, we think there's a good, very strong argument that it does not apply to a loan. It applies to either credit sales contract or an interlocking loan. So for example, if a traditional installment lender made a loan that was secured by a vehicle, that we think there would be good argument that the anti-deficiency statute, as plaintiff's counsel referred to it as, would not apply. So we suspect that may be at least part of the reason summary judgment was granted there, but that will be coming out soon. In the meantime, until we have a decision in Wisconsin, there's risk that creditors could be the target of one of these actions. Even like we're seeing most of these cases, the notices are fully compliant with the UCC. So it could be worthwhile to consider taking a look at the notices and potentially taking other mitigating efforts to reduce the risk of one of these claims. And one of those possible approaches would be to, of course, take a look at your arbitration agreement if you have one, and if you can control that, because of course then you could get into arbitration and at least avoid the class action. And then, as I mentioned, then another possible defense is that the statute at issue should not apply to loans. And additionally, we think there's a good argument that compliance with the UCC safe harbor notices should be enough, and that the Wisconsin Consumer Act statute at issue 425-210, based on the plain language, should be limited to deficiency judgments. But a court has not addressed that yet, and it's yet to be seen how a court would decide that on summary judgment. And then another option is, of course, considering modifying the post-repossession notices. But even if you take that approach, there until there's a decision, there's potentially a risk that if you alter the notice to comply or to refer to the fair market value, that you could face a claim for violating the UCC. So really, what it comes down to is there's not a great answer until there's a decision, but we definitely think it's worth taking a look at in the meantime to try to mitigate the risk of facing one of these class actions. And then I think I will hand it over to Kat.
Thanks, Natalia. So we are going to pivot away from our discussion away from post-repossession notices and discuss a Wisconsin Court of Appeals case that addresses and impacts the addition of an arbitration agreement to existing contracts. So starting with the facts of this case, the plaintiff opened an account with the credit union in 1991 and entered into a membership agreement at that time. At the time, the membership agreement did not include an arbitration provision. The membership agreement did, though, include a provision that allowed the credit union to change the terms of the agreement and provide notice if required by law. In April 2021, the credit union sought to add an arbitration and class action clause to the membership agreement. And for ease, I'm just going to say arbitration clause, but just note that it was an arbitration and class action waiver clause. The credit union sent a notice to its members explaining that the credit union was adding an arbitration clause to its membership agreement and that the clause would be effective within 60 days of the notice unless the member opted out, as provided in the arbitration clause. The notice also explained that the clause would apply retroactively, meaning that it would apply to claims filed that were filed after the effective date of the arbitration clause, but that the conduct had occurred before the effective date of the arbitration clause. And then finally, the notice provided that that a member indicated his or her acceptance of the clause by failing to opt out and continuing its membership with the credit union. Notably, and we'll get into this a little bit more when we get into the court's decision, but the opt-out provision in the arbitration clause provided that the member could opt out of the clause by sending written notice to the credit union either within 60 days of opening an account or within 60 days of receiving the notice, whichever was sooner.
So, Kat, to jump in for just a second, the court, I think, found extremely persuasive or troubling the fact that it was retroactively binding, like the person couldn't comply with it if they've been a member for more than 60 days and opt out. So it was impossible to comply with. Yeah, exactly, Lisa, and we'll get into that. But because the spoiler alert, the court found that the arbitration clause was not enforceable against the plaintiff, and in part for the reason that the member had been a member since 1991. So with the notice providing that, essentially they said that the arbitration provision, the opt-out provision of the arbitration clause was not sufficiently clear or reasonable to tell the member what they needed to do to opt out, because in this case, the plaintiff had been a member since 1991. So that was the date that was sooner because the notice was sent in 2021. So it was impossible. It didn't give the member a reasonable opportunity to opt out. So just getting back, and thanks, Lisa, for that. And getting back to the facts of the case, the plaintiff filed a class action lawsuit in July of 2021, alleging that the credit union improperly charged its members overdraft fees from 2017 to 2020. The credit union filed a motion to compel arbitration and enforce the arbitration clause, and the circuit court denied that motion, and the credit union appealed. The Wisconsin Court of Appeals considered a few issues regarding the enforceability of the arbitration clause. However, as we previewed, it ultimately concluded that the arbitration clause was unenforceable against the plaintiff for several reasons. The first reason that the court mentioned was that while the membership agreement allowed the credit union to unilaterally change or modify an existing provision of the membership agreement, the court did not believe that granted the credit union the authority to unilaterally add a provision to the agreement that had not been originally contemplated by the agreement. So the court noted that there was no evidence that the parties, when the membership agreement was entered into, contemplated an arbitration provision at that time. So since there was not, that was not something that the parties had thought about at the inception of the agreement, the court held that the credit union could not unilaterally add the arbitration clause.
With this, the court reasoned that the credit union did not act in good faith when it attempted to unilaterally add the new term to the agreement. And they came to this conclusion because they found that the provision retroactively deprived the other party of legal rights without affirmative evidence that the plaintiff had actually consented to the terms of the arbitration clause. The court explained that in its view, since arbitration agreements and class action waivers limit consumers' rights, the credit union's attempt to add the arbitration clause that applied retroactively to claims was an attempt to recapture a foregone opportunity and protect itself from alleged wrongdoing. Therefore, since the credit union was not authorized to add the arbitration clause, it needed something more than silence to signal that the plaintiff agreed to the arbitration clause. And then with this, as Lisa kind of mentioned before, the court also held that even if there had been, even if the credit union had the authority to modify the agreement, that the plaintiff's failure to opt out and continue to use the account did not constitute his agreement to the arbitration clause, because it was not sufficiently clear to convey to the plaintiff what was required of him in order to opt out. And as we discussed, because the notice or the opt-out provision in the arbitration clause provided that he had to opt out whichever date was sooner, and the court reasoned that logically one could assume that since 1991 was the sooner of the two dates, since he received the notice in 2021, that he could have concluded that his time to opt out had already passed. And then with this, the court also noted that the notice that the credit union sent to its members didn't resolve the ambiguity in that it only provided that the member had to opt out within 60 days of the notice as provided in the arbitration clause. So thus, with all of that together, the court concluded that even if the credit union could have added the arbitration clause, that the plaintiff's failure to opt out did not demonstrate his consent, and was therefore unenforceable against him. So, although to put it mildly, Pruitt is not the best decision for arbitration agreements that are added to existing agreements, there are some important takeaways for any entity that has an existing agreement in place and wants to add an arbitration clause. First, Pruitt, it's important to note that Pruitt does not take away the ability of a company to add an arbitration clause to an existing agreement. However, it just adds some additional considerations. For instance, when a company is considering adding an arbitration clause, it could consider seeking the mutual agreement of the other party. This could include by having the other party click a button that in which they affirmatively agree to the arbitration clause, or that they have the other party sign something and return that to them. If a company is going to rely on silence, it's important that it avoid any ambiguity in the opt-out provision and ensure that the other party is given a reasonable opportunity to opt out. The procedure should clearly lay out how the other party can opt out and ensure that the other party has the opportunity to opt out. It's also important to note that the opt-out provision in the arbitration agreement and the notice that is given to the customer should be sufficiently clear, and the notice that's given to the customer should reinforce the clarity of the opt-out provision. And a big
Pat,
thing.
let me just chime in quick. It's interesting because often we add opt-outs, not because it is necessarily required in most instances. Now, I get this is a different decision or decision that calls that conclusion into question, but ordinarily you include an opt-out because you want to make sure that the arbitration agreement is not considered unconscionable, right? So you give the consumer the right to opt out, and that bolsters an argument that somehow by presenting the arbitration agreement to them, that is an unconscionable act.
And one other thing about this case is that Wisconsin Credit Union filed a petition for review to the Wisconsin Supreme Court asking that court to take up this case. And that was submitted on January 31st. It's possible the court will hear the decision on the petition for review March 19th, or April 16th is the next petition for review conference. The Supreme Court generally denies petitions for review in civil cases by statistics about 90% of the time. So we'll see how they rule on the petition for review.
Thanks, Marcy and Lisa. And then just the final point that I'm going to make on this, considering time, is that with respect to the governing law in an arbitration agreement, it's always the best practice to cite that it's governed by the Federal Arbitration Act. That probably or likely wouldn't have made a difference in the Pruitt case because state law regarding the law regarding formation of contracts is governed by state law, but in general, federal law on arbitration tends to be more pro arbitration. So just keep that in mind. And so now I'm going to pivot just briefly, given the time, I'm just going to briefly touch on this, but I'm going to pivot to discuss a legislative update that's currently has passed the Wisconsin legislature and is just awaiting signature by Governor Evers. So in large part, this bill just amends several statutes that regulate the licensing of several entities that the Wisconsin Department of Financial Institutions oversees. This includes collection agencies, licensed lenders that are licensed under 13809, sellers of checks, and sales finance companies. The bill also just broadly expands the use of the NMLS system for licensing for these entities and standardizes renewal processes using the NMLS system. And then it also makes just a couple changes to the underlying statutes that I'll just briefly go through. One is collection agencies, and just broadly, the biggest change that it makes for collection agencies is that collectors and solicitors currently under the law have to get a license separate from the collection agency, and this bill will eliminate that requirement. It also provides that employees, there is a requirement that the collection, each location of the collection agency must have a license, but it says that that doesn't apply to people who work from home so long as they don't hold their residence out as a location of the collection agency. There are also some changes to the licensed lender statute, and just briefly, it adds a definition of consumer loan. It exempts certain agencies from licensing. It also adds a definition of what it means to do business under 13809, and that would include, in addition to making loans with an finance charge in excess of 18%, also taking assignment of those loans, or directly collecting payments or servicing, directly collecting payments or enforcing a right against such a loan. It also allows licensed lenders to contract with other entities that are not licensed under 13809 to service the loans. So, but clarifies that the licensed lender would be responsible for overseeing any violations and would be responsible for any violations that entity would commit. And also, the bill sets forth the right of licensed lenders to collect a prepaid finance charge. And just a little bit of background on this change. Previously, for 20 plus years, the Department of Financial Institutions had correctly interpreted that 13809 allowed licensed lenders to collect a prepaid finance charge. We've had, in recent years, an inquiry by plaintiff's counsel had caused DFI to question this position. But when DFI introduced this bill, we worked with a trade organization to introduce an amendment to this bill to add this provision, which allows licensed lenders to have prepaid finance charges that are earned at consummation. For sellers of checks, the biggest thing to know is that Wisconsin just adopted a model law that's in line with other states, and it changed from sellers of checks to money transmitters. And sales finance companies, the biggest thing is just that it moves some of the licensing requirements around. And I don't think that we have time. Oh, and just the timeline. As I said, it passed the Wisconsin legislature. The period for gubernatorial review is until April 11th. And if signed by the governor, it'll be effective January 1st, 2025. And we wanted to reserve just a little bit of time for questions. So we're not going to be able to cover the National Bank Act preemption. So just wanted to see if there are any questions.
We do have one question asking if the recommendation is to use the fair market value. If you're using the fair market value to calculate the deficiency amount, do you recommend creditors reference fair market value in the notice? And that is a really great question and is one that probably deserves pretty robust conversation about the approach and the risks. And we'd be happy to talk to anybody offline on that. We've given this quite a bit of thought, but not one size fits all approach may not make sense. So would certainly prefer to talk about that on an individual client basis. But it's a great question. Okay. Well, I don't see any questions coming in. It must mean that we answered all of your questions or we stunned you into silence, one of the two. But we're so grateful that everybody joined us today. It's never a dull moment working in consumer finance, including or perhaps particularly in Wisconsin consumer finance. Thanks so much to my excellent presenters and colleagues today, who I'm grateful to be on this call with, and more importantly, work together on a day-to-day basis. I have some items to discuss to close us out. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to what you need. And I would really like to stress that we love to hear what is happening on the ground with your company or your financial institution. And that helps us all around be better advisors to you and to our other clients. So this concludes our webinar. Thank you for joining and have a great rest of your day. Thanks, everyone.